would begin by doing what the other speakers have done and add the congratulations of the Green Party to Jonathan Coleman and his partner for the new addition to their family. I'm sure it will be a great, joyful time for them. The Green Party will be voting against this bill for the same reasons as it voted against the immigration bill last year, the bill that is now the Immigration Act. This amending bill implements many of the provisions in that Act that undermine civil liberties, and we complained about them during the passage of the original bill. This is not to say, of course, that the Immigration Act is all bad. It does provide a more comprehensive and systematic approach to processing visitors and migrants than the previous Immigration Act, and some of the really bad procedures in the old Act were excluded, such as the security risk certificate procedure that Ahmed Zawi fell foul of. There was a weird provision in the old Act that the Immigration Minister could get a security risk certificate briefing, but it had to be oral and the Minister could not even take notes. And this involved a misplaced trust in the authority of intelligence agencies, in this case the SAS, an agency which got it so wrong in the Zawi case. And thankfully, Mr Zawi and his family, including his children, are now well settled in New Zealand, and he's doing very well. Such improvements in the Act last year, as against the previous Immigration Act, were no doubt behind the UN Human Rights Committee recognising the Immigration Act as positive in many ways in its report that it issued just last week on March 25th, when it considered the application of human rights by the New Zealand government. However, this same UN report also criticises several immigration procedures. It proposes that the Immigration Act be amended to, quote, ensure that no asylum seeker or refugee is detained in correctional facilities and other places of detention together with convicted prisoners. And unfortunately, this is still the case here. The committee also wants the Act brought fully into line with the principle of non-refoulement. This means, according to the committee, that New Zealand should not refuse to hear a refugee claim simply because the applicant could have applied in another country, deemed to be a safe third country, only later to find that that country had deported the person back to persecution in their homeland. And I could give examples of this actually happening, people being deported back to places like Singapore and then on to a country of torture, where they have actually been tortured. The committee also wanted the New Zealand Human Rights Commission to be able to, quote, receive complaints of human rights violations related to immigration laws, end quote. And this is something the Greens endorsed. In fact, we moved an amendment in the committee stages last year of the immigration bill on this very question because, as the Human Rights Commission has pointed out itself, it is wrong for them to be excluded from this important area, the immigration area, which commonly presents difficult human rights problems. One of the big problems in the Act, as it was passed last year, is the more extensive use of classified or secret information in immigration cases. And there are now 11 government agencies beyond the police and intelligence agencies, SAS and GCSB, which are now able to determine their information to be classified and not fully disclosable to the person affected. And these agencies include such things as Aviation Security, Maritime New Zealand, Ministry of Fisheries and Department of Corrections. Now, let's look at section 474 that this amending bill is mainly concerned with. And it does, under the different bits of 474, there are broad powers to designate a person as a refugee and protection officer for the purpose of making decisions based on classified information. And one of the bits authorised by 474 gives the Prime Minister a free hand in designating a body as an agency, enabling it to appoint what is called a special advocate to supposedly handle classified information on behalf of what might be called the defendant or the person affected. But there are two big problems with this special advocate system. And that is that the problem essentially. Hold on. There is a problem with the special advocate system, in that the special advocate is hamstrung in that once they have received the classified information, they can no longer communicate with the person they are supposed to be helping defend, and that means that the relevance and the full context of the information they've received cannot really be understood by the special advocate. And this has been explained by the special advocate in the Zowie case, a solicitor called Stuart Grieve, and he actually presented a submission to the Transport and Industrial Relations Committee on the Immigration Bill, where he was very critical of the whole special advocate procedure and the nature of the classified information he saw, and he told the committee that 90% of it was actually information that should have been in the public domain or was in the public domain but had been wrongly put into the classified information basket. Under the Act, the heads of 14 of these what are called relevant agencies, and I've said that they go well beyond the traditional police and intelligence agencies, they can actually determine through their CEO what is classified and what remains classified, and even the Immigration and Protection Tribunal that is set up under the Act cannot overrule the decisions of the CEOs in that respect. So the state and its departments have veto power over the system, even veto power over the tribunal. The immigration, there is also a problem, there was reference in the introduction to the Immigration and Protection Tribunal, which is being set up now, this amending Act, if it goes through. There is a problem with its make-up in that it doesn't, according to the legislation, have to have expertise in refugee law, and this is a specialist body of law, and it is actually important to have someone on that tribunal that understands it. And it particularly as this amending bill and the Act will extend the rights of detention by government officials. The UN Human Rights Committee said that there should be no detention of refugees and asylum seekers with ordinary prisoners, but unfortunately that is still happening, and in fact under this Act there will be room for them to be detained even longer. There is an extension of the time of initial detention after an asylum seeker arrives at the airport from 72 to 96 hours without any justification being provided for that increase, and 474 also gives immigration officers more powers to detain and can determine that any premises be a place of detention. And this is a really important issue, because we have, particularly in relation to Iranian Christian converts from Islam, periods where they've been detained for very long time. In fact, one of them, Emir Mohabi, who has now been granted status in New Zealand, and he was in jail for 4 years. And I think that this is what is in the Act is quite a challenge to what the UN Human Rights Committee has said, that people, asylum seekers, shouldn't be detained in this way. I think the whole trend of the Act is towards increasing state powers over people coming here to an unreasonable degree. for too much secrecy over those who are being affected by it. Thank you.